The amendment in the name of the noble Lord, Lord Hope.
The noble Lord, Lord McLaughlin, certainly is correct that no legislation was forced on the UK by the EU. Indeed, many ministers from all parties were happy to take advantage of laws made in Brussels, sometimes that they even suggested, and then coming back to the UK and reading out the legal text from the EU Commission, and then if there was any objection, they'd blame the EU. But what was removed from that equation was the scrutiny and accountability of the electorate. They were the people who were told that they couldn't change the law. It was ring-fenced away from them. And that was what voters rejected in 2016. So I just want to be clear what this bill is all about. And I want to do that by quoting the European Commission, because I know that so many of my noble lords trust them and not me. So in October 2021, the EU Commission stated, in relation to a dispute with Poland, EU law has primacy over national law, including constitutional provisions. All rulings by the European Court of Justice are binding on all members, state authorities, including national courts. No longer for the UK. And we're trying to untangle now how we deal with that. Now, in relation to this bill, it is certainly, in my opinion, not the case that Brexit was an act, in terms of reclaiming sovereignty, of a blueprint for saying exactly what laws you would keep or retain, or just getting rid of the EU law, as it were, as an end in itself, but rather about putting the responsibility for choosing which laws to prioritise or reform or even improve in the hands of the government and Parliament, who are answerable to the British people, the electorate. So I have listened carefully to a lot of the very, I think, thoughtful amendments that are being put forward to try and ensure that too much power is not put in the hands of the executive or of Whitehall, as opposed to an accountable Parliament. But I do get anxious about how the arguments are posed sometimes. So just to query a couple of the amendments in this group. I really appreciated it when the noble Lord, Lord Hope of Craighead, emphasised that he was trying to find ways of finding a quick and simple solution, as quick and simple as possible. Because I do worry that the removal of the sunset clause, as we've previously discussed, might mean a loss of sense of urgency in our task, our obligation to rejuvenate and improve laws now that, that we're in charge of them. There is a popular, the idea, by the way, outside of this House, that what's happened is that things are being rushed through is unconvincing. This process should have started when the electorate voted in 2016 and instructed parliamentarians to get on with it, but it didn't. So it's dragged on. So sometimes I think that when people say this is being rushed through, it neglects to mention that that's because we didn't do anything for so many years. And therefore now there's a sense of urgency. I mention this because I'm concerned that some of the attempts, even by the government, to remove the sunset clause in the way that's previously been discussed, will breed cynicism and a distrust in the electorate about a breaking of promises and the possibility that this is just a delaying tactic. So I'm very pleased to hear, noble lords, those who are putting forward the amendments, as I've said, being aware of the time issue. The sheer number of EU laws and regulations, it seems to me, just grows daily. I mean, every time I look, it's gone up another 1,000 or what have you. And I've found the invaluable research organisation Facts4EU.org, who keeps track of this. It seems almost ahead of the official tracker. has noted that 4 substantial departments, including the Health and Safety Executive and the Department of Energy and Net Zero, have only just started reporting. So you know that it's just going to go up and up and up. And I think the sheer mind-boggling numbers and scale does indicate how much of our sovereignty as the UK was undermined by that many laws and regulations not made in the UK and accountable to the British public. But I was very struck by the question that the noble Lady Baroness Butler-Schloss asked earlier, when she just said, where will it all end? And I do think that that's a very good question in a way. That one feels that even if the government or those putting forward the amendments had a sense of real urgency, that you would count, that you would say there is a definitive time in which we will have absolutely said that this is laws that came in relation to the EU, that would be helpful and at least give a sense that now that we don't have the cliff edge to fall off and all of those unintended consequences and so on, that this was being taken seriously. The only other thing that I wanted to mention was that I fear that one of the consequences of the fact that so much law was not made directly and so many policies were not designed directly by UK legislators and politicians is that possibly we've lost the art of lawmaking because we, as it were, outsourced it elsewhere. I'm concerned, therefore, that we get on with the job of improving legislative processes. Although I was very sensitive, as was mentioned earlier, I am no fan of SIs, of delegated powers, too much power to the executive, but I don't want to necessarily use this bill to try and resolve all of those problems, although I would like to see those being resolved. I'm concerned that the solutions being put forward at the moment, though, actually involve yet more delegation of powers, because even the joint committees of Parliament, it seems to me, are not entirely open to improved lawmaking. And I wanted some assurances from those who are proposing that as the remedy, that these will not become, dare I mention it, an extension of the blob or some of the prejudices in this House. I noticed earlier, for example, when the noble Lord Stewart was speaking, there was a huge amount of grumbling and complaint and so on. I actually made a mess of the rules by trying to stand up and defend someone earlier by, I thought, asking a question and then being stopped from speaking, because I felt that it was unfair that somebody was being accused of making a second reading speech when it wasn't second reading, and I was trying to explain why, blah, blah, blah. The reason I'm saying that is because this House is not necessarily representative of the electorate of this country. We're neither
That's
voted...
true, it's not there, absolutely.
Indeed.
Not at all.
So that is true. Well, for once, my noble lords are agreeing with me. This House is not representative of the feelings of the British public. Therefore, the joint committees of the parliaments, including many from this House who are hostile to what the British public voted to do in the past, I am simply asking whether that is the solution to resolving the problems that we face in terms of our unentanglement from the European Union's lawmaking.
Oh, thank you.
It's time. Could she tell us then what bill is the ideal bill to bring an end to constant use of statutory instruments?
My Lords, I apologise for intervening again. The rules on report found in the companion are very, very clear about speaking once on report.
My Lords, amendment